In this section of our discussion of school law and policy, we're going to address the relationship of students and school personnel with respect to students' rights and freedoms guaranteed and protected by the first 10 amendments to the Constitution, the Bill of Rights. Certified school personnel acting in loco parentis may exercise reasonable control over students regarding conduct and academic expectations in schools, since students enjoy many of the same constitutional rights as adults do. Their rights must be recognized and respected by school personnel. Student rights may be restricted as long as school personnel have a legitimate basis for doing so. The burden rests with the school personnel to determine that a legitimate state interest is formed in the basis of imposing restrictions on student rights. And so as we get into this, we'll start with the First Amendment, and it's important. We've already discussed religion, but looking at the different freedoms, the freedom of speech, of the press, peaceable assembly, petition the government for redress. These are all really balanced in this notion of the First Amendment says Congress shall make no law versus the idea of a clear and present danger and the reasonableness of the rules and restrictions that are put in place by school personnel to create an orderly environment. So school officials have to promulgate rules and regulations governing student behavior, with the caveat that the exercise of this authority should be reasonable. And so this clear and present danger test is the first test. That's a test for the overall world outside of schools. In schools, you have to look at reasonableness. So these rules must be stated clearly, communicated in a manner that allows students to grasp their meaning with undue difficulty. And it's important to note that this concept of in loco parentis, in place of parents, is not a license to treat students in an arbitrary, capricious manner, the way perhaps some parents do to their children. There must be sufficient justification to support enforcement of rules, regulations, if challenged by parents or legal guardians. And so the courts have basically supported reasonable actions by school officials to do this. A fair and reasonable exercise of administrative authority will generally withstand court scrutiny. Oftentimes, it's necessary to assess these rules or regulations in the context of how it's applied to specific situations, which we'll do some in class. Reasonable rules are those that do not violate the rights of students. Reasonableness requires prudence by school officials and teachers, which means their actions must be consistent with those of the average parent under the same or similar circumstances. So the average parent, not all parents. Courts, in assessing the legality of a rule, require evidence of sufficient justification by school officials regarding the need to enforce this policy or rule. So reasonable regulations are those that contribute to facilitating the educational process. And so that's where you get into the very context of freedom of expression. And the freedom of expression is derived from the First Amendment. They enjoy these First Amendment rights subject to reasonable restrictions. In exercising First Amendment freedom, they infringe upon the rights of others. And it's the idea of the freedom of speech does not mean you can yell fire in a crowded theater. If the exercise of First Amendment freedom creates material or substantial disruption, then it may be restricted. And so as we look at this freedom of expression, the case in freedom of expression that we will talk about is the Tinker v. Des Moines Independent Community School District case. The Tinker case is considered a landmark regarding the freedom of expression of student rights of free speech. 3 students wore black armbands to school as a form of silent protest to the Vietnam War. And these students were suspended, even though there was no evidence that their protests created a disruption in the school. And school officials disallowed the wearing of armbands, but allowed students to wear other symbols. The U.S. Supreme Court held for the students. In essence, the court stated that it was unconstitutional for school officials to discipline students for a peaceful form of symbolic expression absent a showing of substantial or material disruption. Wearing of armbands is a form of expression protected by the First Amendment. This case is significant because it defined the scope of students' freedom of expression rights in public schools for the very first time. It also placed restrictions on school officials' authority in freedom of expression cases involving students. The Tinker case redefined the relationship between students and school officials with respect to the constitutional protections of students in public schools. So it's important to understand that students do not shed this free speech at the schoolhouse gate. Famous quote from the case. There are several other cases. There's in the Blau v. Fort Thomas District, which is a Kentucky case that went to the Sixth Circuit Court of Appeals in Cincinnati. It upheld a dress code that does not violate a student-free expression. But one of the most interesting and difficult cases is the Nuxall versus the Indiana Prairie School District. This is an Illinois district, not to be confused. That basically opposed a student day of silence, where a student opposed the day of silence and wore a T-shirt that said, "Be happy, not gay, my day of silence." He was required to ink out the "not gay" phrase by school officials. To avoid discipline, the student did not wear the T-shirt the next day. However, he sued the school official, arguing that the First Amendment permitted his expression. The U.S. Court of Appeals Seventh Circuit in Chicago found that the school banned "be happy, not gay" under a rule forbidding derogatory comments regarding race, ethnicity, gender, sexual orientation, and they found that that was reasonable. The slogan, however, was not derogatory or targeted. It was very subtle. The court did not order the school to suspend its rule pending the outcome of the student's lawsuit, and it allowed the student to wear the T-shirt on a preliminary basis. What does all that mean? Well, the courts are consistent in banning slogans that mock others on the basis of race, gender, ethnicity, religion, color, nationality. In other words, if they're hateful. Courts are also consistent in disallowing slogans that create material and substantial disruption to the educational process. The courts require proof of evidence that a particular student's expression will pose a significant threat to an orderly environment. And they recognize that students possess First Amendment rights that cannot be violated unless there is a compelling reason to do so. And so it's a very, very delicate issue, a very sticky wicket. In this case, the student was able to continue because it was not a material and substantial disruption. But the question really weighed that against the fact that were these slogans that mocked others on the basis of their particular rights and beliefs as well. The school newspaper issue is also a fundamentally challenging circumstance that high school officials particularly have to face. And that is really was decided in the 1980s with the Hazelwood decision. In this case, drastically changed how student publications are governed in schools. School officials do not offend the First Amendment when they exercise editorial control over the content of a school newspaper, as long as their actions are reasonably related to a valid educational purpose. The U.S. Supreme Court held that a school-sponsored student newspaper published as part of a journalism class that is part of the curriculum of the school does not qualify as a public forum. It is an educational setting. A similar ruling was reached in the Bethel case, which involved a student using lewd speech in a speech where he was running for student council. The school was able to limit that student's speech because the speech was inappropriate and educationally devoid of anything of value. The Hazelwood decision, the principal reviewed the material in the student newspaper and deleted 2 pages containing articles, one on divorce, the other on teenage pregnancy. And the principal, they said in the case that the principal did not offend the First Amendment by exercising control over a school-sponsored newspaper. In a pretty conservative decision, the court wrote that the court wrote that school facilities, including those that are used for school newspapers, became open forums only when the school intentionally opened them for indiscriminate use by the general public on some segments of the public, such as student organizations and other sponsored activity. And so school officials can exercise this kind of editorial content over student speech. The bottom line is the freedom of the press extends to who owns the press. And in this case, the school district owned the press, and it was being used for a legitimate educational purpose. And so school officials have the responsibility and the right to exercise this type of censorship. And so let's talk a little bit about the Fourth Amendment and the search and seizure provision of the Fourth Amendment. The Fourth Amendment search and seizure provision talks about protection of all citizens against unreasonable search and seizure by the government. Since school officials are considered governmental officials for the purposes of the Fourth Amendment, they are subject to standards of reasonableness regarding privacy rights of students. So public school teachers and administrators are held only to the standard that we call reasonable suspicion, rather than the highest standard that you hear about in all the law enforcement shows, and that's probable cause, which is required of law enforcement. Now, it's important also to distinguish that if you have law enforcement in your school, like a school officer, a school resource officer, they have to abide by the standard of probable cause, not reasonable suspicion. But school officials only have to operate under the standard of reasonable suspicion. And this was established in the landmark case, New Jersey versus TLO, which addressed the legality of school searches. And of course, searches involving student desks, lockers, book bags, automobiles, the use of drug dogs, strip searches, are all things that are covered in this provision. So the New Jersey case emerged when an assistant principal searched the purse of a student who denied that she had been smoking in the restroom. The search was conducted based on her denial to ascertain whether her purse contained cigarettes, and the assistant principal discovered cigarettes as well as rolling papers commonly associated with other drugs like marijuana. A further search revealed marijuana, a pipe, plastic bags, a large amount of money, and a list of students who owed TLO money. The student moved to suppress the evidence and her confession by arguing that the search was unlawful. The key issue was whether the Fourth Amendment requires school officials to obtain a search warrant or show probable cause, like the police have to show, before initiating the search of the student. The U.S. Supreme Court stated that a warrant requirement does not apply to school official. This notion of reasonable suspicion is what's necessary for these searches. So in loco parentis cannot stand alone in the absence of reasonable suspicion. School officials have that right. There's a host of other cases that are mentioned. The Watkins versus Millennium case is an Ohio federal district court that held a teacher's search of an elementary student, which involved looking down the student's pants, did violate the First Amendment search and seizure. So that reasonable suspicion is not a bulletproof in all circumstances. AH versus State is a Florida case, an appellate case that held a school administrator's search of a student wallet was not constitutional, and they concluded that there were no facts which combine with rational inferences that warrant the search. The cell phone issue is also a pretty significant issue, and one of the landmark cases at the appellate level is a case that involved the Owensboro Public Schools. And I received the final rendering of this as I started my job, although the case did not initiate under my watch. The U.S. Supreme Court has heard two different non-educational cases that deal with privacy rights versus law enforcement prerogatives to access information on the cell phones. The searches conducted by law enforcement involved the search of a criminal cell phone without a warrant. Opponents contend that a cell phone is protected against unreasonable search based on vast amounts of personal information contained on the phone. In rare unanimous decision, the U.S. Supreme Court ruled the police needed a warrant to initiate a search of the cell phone of people they arrest. The fact that technology now allows an individual to carry information in his hand doesn't make that information any less worthy of protection of Fourth Amendment rights. And so this will likely appeal to or apply to all kinds of searches based on electronic technology like cell phones, computers. The reasonable suspicion standard still stands in schools, but it's one that is really untested, and there's some conjecture because the reasonable suspicion standard must really be reasonable suspicion, not just if you're searching the student or if you suspect the student did something, you'll find it on the phone. So you have to be very careful. Strip searches should also be viewed as searches of last resort in circumstances involving the health and safety of students under the school's jurisdiction. And they are viewed as the most intrusive form of all searches. And therefore they should be handled very cautiously and carefully. As one court stated, the Anchor case, as the intrusiveness intensified, the standard of the Fourth Amendment reasonably approaches the probable cause standard, even in the school context. So your standard should elevate and escalate when you deal with highly personal things. The cell phone is a notch above in personal and is certainly strip searches. And this, of course, is what occurred in the Cornfield and the Safford United or Unified cases. Both involve students and their personal almost strip searches, but not to that standard. The Cornfield by Lewis case involved a student who had a bulge in his trousers and was thought to have drugs, and the school officials initiated the strip search over the objection of the parent and the student, who alleged that it was an unreasonable violation of the Fourth Amendment. The court held for the school by stating that privacy rights of students versus the need for school to maintain order does not require strict adherence to probable cause. So in this case, that bulge was enough to give them the right to do so. The Safford case is a little different. It involved a strip search of the student's bra and underwear based on another student's claim that she was given prescription drugs and over-the-counter drugs by the student who was searched. The courts held that the mere possibility that the student might be hiding something in their underwear did not justify, so it wasn't like the bulge. The cell phone case that we dealt with in Owensboro was very similar to that, where it was a case where there was the mere possibility, and the court ruled against the school district's search of the cell phone, stating really that this mere possibility standard does not really constitute or elevate it to the level of reasonable suspicion even. Alcohol and breathalyzer testing can be administered by school officials, but there are conditions. The district has to have a policy that authorizes it, and there needs to be reasonable suspicion that a student's under the influence and the student's condition poses a safety risk to himself or others, and they're administered by trained personnel or police officers. Students are attending school-sponsored events, that's fair game, and they're administered privately. The exception to that is when you administer them to every student, as you do with proms. That's a little bit different, and the standard is a little bit different. Let's now move to the last two of the 10 amendments that we're going to talk about here, and this is the Fifth Amendment and the Eighth Amendment. The Fifth Amendment is the Due Process Amendment. This applies to federal government, where the 14th applies to the state government. In either case, each one prohibits the government from depriving a person of life, liberty, or property without the due process of law. Due process requires fundamental fairness, fair processes, and fair procedures. There are four aspects of due process applied by the courts regarding issues involving an individual's constitutional rights. The two primary aspects are procedural, the process and the procedures you go through, and the substantive, which means that there has to be something of substance there to warrant that. And they ensure the proper and fair procedures when a person's rights are in jeopardy. The substantive aspect ensures that there's a valid reason for doing this. The two other aspects involve tests that the courts apply in safeguarding constitutional rights. The vagueness test addresses fairness and protects against arbitrary and capricious government actions. And the vagueness test stipulates that law or policy is impermissible if the individual is of common intelligence and must necessarily guess at their meaning and differ regarding the law or policy being applied. And of course, this is making sure that it's being not vague, that it's fairly clearly communicated to an average intelligent person. The irrationality or presumption test requires that the state demonstrate that it has a legal basis prior to depriving or restricting an individual's rights. And so all aspects of due process apply to public schools by virtue of the 14th Amendment. Students as well as faculty must know what's expected from them in a school environment. Vague and ambitious policies or ambiguous policies will not receive support in the courts. Arbitrary and capricious action by school officials will also not be supported. And due process guarantees fundamental fairness. And there's a couple of cases here that focus on both procedural and substantive due process. Inri Galt is an example of a procedural due process violation that's illustrated in this case. Gerald Galt was a juvenile found guilty of making an obscene phone call, not in a school setting. The typical punishment for committing this offense would have been a $50 fine. Galt was a juvenile. He was remanded by the court to the state reform school for 6 years. And the U.S. Supreme Court held that Galt had been committed to this school without benefit of procedural due process. The court overturned the decision. And so the Supreme Court ruled that the youths are protected under the 14th Amendment and that a substantial infringement on child's liberty and interest. And so children's due process rights include the right to an attorney, the right to confront a witness, the right to remain silent, and to view written charges. But the main school case that is the standard bearer is Goss v. Lopez. This is an Ohio case where the statute permitted principals to suspend students up to 10 days without providing notice or reasons for suspension or a hearing that would enable them to respond to charges. Several high school students were suspended for 10 days without any type of hearing. They challenged the constitutionality of this. And the U.S. Supreme Court, in holding for the students, stated that the students who were suspended for 10 days or less must receive oral as well as written notices of the charges, an explanation of evidence if the students deny any charges, an opportunity for the students to present their view of the incident. These procedures must precede a suspension unless it becomes necessary to immediately remove them because of a threat to the health and safety or property or the academic process. Once a threat has been issued, due process requirements must be met. So all students enrolled in public schools are entitled to this fundamental fairness. Both aspects of due process, substantive and procedural, must be met in suspension and expulsion cases. Meeting one aspect of due process while not meeting the other aspect will generally result in a reversal of the administrative action if challenged through the courts, as seen in the Galt case and the Goss v. Lopez cases. The fundamental fairness must guide all administrative action because it's the right thing to do. Students do not shed their constitutional rights at the schoolhouse door. Corporal punishment is in leading cases involving corporal punishment. The U.S. Supreme Court held that the 8th Amendment prohibition against cruel and unusual punishment does not apply to disciplinary corporal punishment in public schools. Ingram v. Wright is the case. 2 students filed suit after being subject to paddling that was viewed as severe. The students alleged that their punishment was cruel and unusual according to the 8th Amendment as well as the 4th Amendment. The court concluded that the students were protected against flagrant abuse by criminal statute of the state, but not by cruel and unusual punishment provision of the 8th Amendment in a school setting. In short, the 8th Amendment does not apply to the school environment. And so any type of expulsion, suspension, or punishment, the due process piece is really important. The last thing is really looking at is looking at harassment, and public schools have codes of conduct that govern student behavior. Who violate those codes, they're subject to disciplinary action with due process. The Davis versus Monroe County Board of Education case involved a Black student who alleged that she was sexually harassed by a classmate on repeated occasions, and she reported these incidents over a period of several months to her teachers and later to the principal. The student accused of harassing behavior was not disciplined until a similar incident was reported by a white student. The plaintiff's mother brought charges seeking monetary damages and relief under Title IX, which we'll talk about later. The mother further alleged that the harassing conduct by the student deprived her daughter of the opportunity to receive an education. The court, in its majority opinion, brought clarity to these issues involving sexual harassment and harassment in general, in indicating that lawsuits are only valued when the harassing student's behavior is so severe, pervasive, or objectively offensive that it denies the victim equal access to education by federal law. And so as school administrators, you have to be aware of student-to-student sexual harassment, and failing to act can hold you liable. So schools are unlike the adult workplace, though. Children may regularly interact in a manner that would be unacceptable among adults, and so the standard is a little bit different. If evidence suggests that school officials should have known of the harassing conduct involving students and failed to act, liability charges still could be brought by the victim. Harassment in any form constitutes discrimination for whom the harassment is directed. And so these federal statutes that govern this form of discrimination and harassment, Title IX, the amendments of the 1972 Education Title VI Civil Rights Act, these are all things we'll talk a little more about when we deal with employee issues. But the courts are increasingly concerned with the quid pro quo allegations due to students involving these power and authority relationships, even student-to-student type of situations based on differences with race and gender. And so this is also a very tricky situation, but it's one that school administrators have to pay close attention to as you deal with this.